Good afternoon and welcome to the City of Sacramento's webinar series. My name is Darren Gale and I'm with the city's Office of Economic Development, Innovation and Economic Development. Appreciate everyone joining us today for a great webinar. Our webinar series is every Wednesday at 2 o'clock, Resilience, Repurpose, and Recovery. And today's program is about the city's free landlord tenant mediation services. And we have a great program, a great number of presenters. And at this time, I will turn it over to our housing manager for the City of Sacramento, Danielle Foster.
Thanks, Darren, and hello, everybody. This is the second in a series of webinars we've done related to our local eviction moratorium. So first, we're going to provide an update on the eviction moratorium, and then we're going to talk more about the mediation services that the city is providing at no cost. The first eviction moratorium webinar can be found at the Tenant Protection Program website for the city, which is at www.cityofsacramento.org/TPP for Tenant Protection Program. And then I also just want to let you all know that if you have questions while we're going through the webinar, if you could put those in the chat box, that would be great. And we will come to those at the end of the program and ask those questions of the panelists. So I want to go ahead and introduce the panelists. First, we have Tina Lee Vogt, and she is the program manager over our Tenant Protection Program, which is the office that has been administering the city's eviction moratorium. And then secondly, we have Jody Pruner. She's an associate director with the California Lawyers of the Arts, and she's the director for the Sacramento Center and overseeing our Sacramento Cares mediation services. I'm Danielle Foster, the city's housing manager, as Darren already noted. So let's go ahead and get right into, here's the overview of our agenda. We're going to have an overview of the moratorium update that's occurring, the Sacramento Care mediation services, and then we're going to get into some frequently asked questions as it relates to mediation. And then we'll dive into any questions that come up in our chat box for the panel, as well as reviewing some of our COVID-19 resources. I'm going to pass it over to Tina to get us started on the overview of the moratorium updates.
So good afternoon. Again, my name is Tina Lee Vogt. I'm the program manager over the Tenant Protection Program. So just a quick overview of the moratorium itself. So in March, City Council established the moratorium for residential and commercial evictions to assist tenants that have been impacted with a loss of income due to COVID-19. The moratorium for all residential and first floor retail commercial tenants is set to expire on September 30th of this year. The moratorium for all other commercial tenants has already expired on June 30th. All of the tenants will have up to 120 days after the expiration of the related moratorium to pay any unpaid rent through a repayment plan. So we just wanted to go over a few key dates because it can be confusing because there's two dates for expiration. So again, for residential and commercial, the moratorium ends September 30th, which means that unpaid rent would then be due by January 28th of 2021. For commercial tenants other than first floor retail, the moratorium has already expired, but they still have a bit of time before they need to start paying back that unpaid rent. So their unpaid rent is due October 28th, 2020. And again, it's always great to go to our website, www.cityofsacramento.org/TPP. We consistently update information on the moratorium or any council actions that are taken. So just to cover in terms of residential tenants who's protected, all residential tenants are protected, and this includes single family residences as well as condominiums. And again, they have to have a loss of income that's related to impacts for COVID-19. So that means either the tenant is sick or they're caring for a sick family member or household member, they've had a layoff, a loss of hours, or some other income reduction due to COVID-19. They're complying with a recommendation from a government agency to stay at home or self-quarantine or avoid congregating with others, or they've had to miss work to care for a homebound school-age child. So what's really critical to note is that the commercial tenant protections changed as of July 1st, 2020. Commercial tenant protections are now limited just to first floor retail businesses that have a loss of income due to the tenant's closure of operating restrictions that have been placed on or other loss of patronage that are directly a result from COVID-19. So that's an emergency order has been declared, their business can't open. So anything that's been related to COVID-19 that impacts their business and results in a loss of income. So just a few key things to note in terms of requirements for the tenants. There are requirements that the tenants must do if they want to be covered. First and foremost, they need to make sure that they notify the landlord in writing prior to when rent is due. They also need to be very sure to provide the appropriate documentation that's related to the loss of income. So for example, it might be a paycheck, it might be a notice of being laid off, but to be covered, it's very important that that tenant provides that information to their landlord. They should pay a percentage of rent that they can. So even though it may be tempting for a tenant to say, I can't pay anything, it's really important that folks remember they do have to pay this back. So if they're getting any type of income, they should put as much as they can toward that rent so that later on they don't have to repay as much. And again, they need to provide the notice and documentation for each month that there's a delay in the rent payment. So with that, I'm going to go ahead and pass it over to Jody. One of the things that we're really excited for in terms of the tenant protection program is being able to partner with the Sacramento Mediation Center to really assist us in providing a great resource for folks, because what we're learning is communication is key for this to be successful and for people to be able to utilize the services that we're providing with the delay of rent, as well as other rent mitigations. So Jody?
Sacramento Mediation Center, we've been dealing with conflicts for a long time between landlords and tenants or neighbors or personal disputes or business disputes. But this is a special program dedicated to landlords and tenants who have issues related to COVID-19 problems, and it is free, thankfully provided by the City of Sacramento, as long as funding lasts. So what is mediation? That is very helpful to understand that, because a lot of people, I think, are afraid that perhaps a judge will come in and set an agreement, or that we might come in and set an agreement, and that is not the case. So mediation is a confidential and voluntary alternative dispute process where the mediators set the rules and the framework for participants to have a safe and productive conversation. And the conversation that we have is with all of us in the same room. Well, usually in the room. The mediation process builds trust and communication between the participants so they can explore issues and options in their situation. And I can say that of the calls that we've had so far, many of the people, both landlords and tenants, have complained that they cannot communicate with the other side, or they fear that someone is not trusting them, or they may not trust someone. And luckily, they realize by calling, they may be able to reach out to the other side and have that kind of conversation that does build trust and does build a relationship, so that the parties can hopefully work together and work out some of these dilemmas like we have never really seen before. So what the mediators do, first, they are trained. They help people listen, speak one at a time, speak in civil language, listen with an open mind, think about what the other side is saying and the position that the other side is in, and then hopefully brainstorm the world of possibilities, moving closer and closer to a possibility that would work for both sides.
Excuse me?
Yes.
Jody, could you speak up a little bit? Folks are saying they're having a difficult time hearing, so maybe you could scooch in or...
Yes.
Yeah.
Okay. All right. So mediators help people listen, speak, think, brainstorm, and hopefully arrive at a solution or an agreement that is suitable for everybody. Mediators do not advise, they do not counsel anyone, they don't judge the agreement made between the parties, they don't allow an illegal arrangement to be made. But even if a mediator is a lawyer, they do not advise as to the law. They set the stage for the parties to work together. All right, so there's a lot of questions that people have about writing the actual agreement. And one of the first questions we get is, will the mediators tell me what to write in my agreement? And the answer is no. Mediators are neutral. They are impartial. We are third-party neutrals, and sometimes even called neutrals. We do not direct the solution at all. We do not take sides at all. We help the parties speak, find their own voice, find the direction they would like to go in, explore the options. But the mediators do not write the agreement. They may be the scribe to physically write what the other people, the participants, are actually talking about. What if I do not agree with the other party's position? Okay, so the mediator helps the parties identify their interests and their needs and their concerns, as opposed to their positions. But once the parties have a better understanding of the person's position or issue, they then may be able to see how they can settle their differences. Parties are encouraged to keep an open mind throughout the process, because you never know when someone is going to speak something that may become important, that you may need to come back to 1 hour later. So the process is what is very important, because we assume that when participants come to the mediation, they are on opposite sides at that point. They haven't been able to work out their differences. So we assume at the outset, when we first walk in the room, that the parties are not going to be in each other's corner. It takes that process for people to understand what is going on with the other side and what their position really may be, and things that they maybe even haven't thought about before. So we encourage everyone to keep an open mind and really hear and listen to what the other party says, and no one has to agree to anything they don't feel comfortable with or they're not certain about. Many people ask whether a lawyer is needed. A lawyer is not needed in a mediation, but it might be that participants would like to bring their lawyer. Many times, participants would like to consult a lawyer so that they can understand, for instance, if their business leaves or goes out of function and they need to go into bankruptcy, how would that affect things? Or if they get a job but it doesn't pay as much, how would that affect things? So sometimes people would like to know their rights and feel more confident about their rights before they come into a mediation. Also, once we're in a mediation, if parties feel like they need to take a break and learn more about their rights, they can leave and consult a lawyer and come back to a mediation. And of course, if they're in a mediation with their lawyer, they can consult with their lawyer at any time. All mediations are confidential. Anything said in the mediation cannot be used against someone in court. No one waives any rights by coming and attending a mediation. A mediation is often a win-win arrangement at the end. Even if there's not an agreement, it still may be a win-win proposition, because each party may have learned a lot about the other side and may be in a better position to communicate outside of a mediation and in a better position to be able to trust the other side. Who are the mediators? Okay. Mediators can be lawyers. They can be doctors or businessmen, artists, students, working or retired. They do come from a wide variety of backgrounds. We train mediators. That's part of what we do. We also take mediators that have been trained elsewhere, but we kind of orient them to our organization. And so by the time the mediators are working with participants, they are skilled in working with a wide range of parties, conflicts, emotions, and issues. We often use co-mediators. The benefit of a co-mediator is that they are working together. Neither is working for one side, but the parties can often observe how the co-mediators are working together, what suggestions they make to each other. And the co-mediators may be able to listen and hear different pieces of the mediation at different times. So when possible and appropriate, we use co-mediators. They help to facilitate the mediation and get the parties to share their perspectives. Where do the mediations occur? Well, they used to occur in our office, but with COVID-19, it is much safer to do them on the Zoom platform. So we use the Zoom platform when possible. If it's not possible, we use a teleconference line. So when video is not possible, we use a regular old telephone. And when parties are comfortable and facilities are available, we can explore holding mediations in person in a large conference room with the necessary precautions. Many people ask, what is the difference between mediation and litigation? Litigation is something that occurs in court. It's a public legal process. The judge makes the decision. In mediation, it is private and confidential. In court, so the judge makes the decision, and that is basically a directive. One party wins, another party loses. In mediation, the parties can seek a broader range of options and look for win-win solutions. And they can brainstorm all sorts of options that just are not available in the courts. Going to court is more expensive. It takes more time, and it has an emotional cost to it. Mediation can be offered quicker. It takes less time, and here it's free.
Thanks, Jody. I just wanted to highlight some of our local COVID-19 resources. I know a lot of these have been displayed on previous webinars, but I just wanted to remind everybody. First off, I wanted to make sure everyone had access to our mediation services phone number and email. So they're listed here. That's the 916-850-9010. So you can call that number to get more information about mediation services. And then, of course, we have our resources that we've been talking about related to the eviction moratorium. And if you need any assistance accessing the mediation services or other information about tenant protection program, we have the city's website, email, and phone number here for the tenant protection program. And I just wanted to reiterate the business resources, since we're focused on our business community with this webinar. So we have both the triage hotline listed here and the city's small business COVID-19 hotline and email. So now we're going to look at the chat and see what information we could provide in response to the questions that are coming up. I'm just going to go into the chat. Are mediators lawyers? Do you want to address that one, Jody? I know you covered it a little bit in the FAQs, but if there's anything you want to add, and you could speak as loudly as possible. I think we're still having some challenges with the audio.
Okay. The mediators may be lawyers. Even if the mediators are lawyers, they cannot advise any party. They cannot draft an agreement which they think would be appropriate. So often we will have a lawyer mediator and a non-lawyer mediator together as co-mediators. So the answer is the mediators might be lawyers. They don't have to be. And even if they are, they cannot provide advice. I hope that clears it up.
And in the context of mediation services, it's not their lawyer skills that they're using, it's their mediation and facilitation skills that they're using, correct? To help people hear and communicate with each other.
Absolutely, yes. They are retrained. I'm a lawyer, but I'm also a mediator. And as a lawyer, we're trained in one direction, and as a mediator, we're trained in another direction. But at the mediation, we are mediating, facilitating, as Danielle said, and not lawyering, not using our lawyering skills.
So we have another question about the power imbalance that can occur in a mediation setting. So the question is, how are mediators able to address the inherent power imbalance between landlords and tenants?
Okay, that is an excellent question, because there certainly appears to be a power imbalance. And that is one of the things that the mediator or mediators are very conscious of in any mediation. That is one of the reasons why in mediation, we like to hear from the parties themselves and not necessarily the lawyers. We give equal time to each person to be able to discuss the issues that are of concern to them. If we go into a private caucus to discuss something special with one side, we take the same amount of time and go into a private caucus with the other side. So the mediators try to do the best to level the playing field so the mediation can be productive. I hope that answers that.
Great, thanks, Jody. Another question about the mediators, specific to their training. What type of training do mediators receive in order to provide culturally competent mediation services to the diverse communities in Sacramento? And how can someone become a mediator if they're interested in serving in that way?
Okay, we do. This is also an excellent question, a very, very good question. So you can contact me at this number, 916-850-9010, and we can put you on a list if you would like to be trained as a mediator. We have trainings about twice a year, and so that's a great time to learn the skills of being a mediator. Our trainings are about 25 hours. They comply with the DERPA statutes. And so in the training, we go through a variety of important pieces of information. So for instance, mediation is one alternative dispute technique. There are others. So negotiation, conciliation, facilitation, arbitration, and mediation are some. And so we go through some language and semantics and some basics about the processes themselves. Then we get down to business. So we learn active listening, how to ask open-ended questions, how to talk about empathy, how to reframe, how to restate questions, how to feed back to someone what we believe they've heard, how to conclude a sentence, how to let parties speak, all about confidentiality, all about voluntariness, all about emotional intelligence. So we have a variety of things that we cover. And then we get down to role plays. And that is really kind of where the magic happens. And so we coach each student on answering, being in an actual role play where there are two parties to a dispute. We use a wide range of disputes. And the mediators go through how they ask questions of each side to determine what is going on, what is a hidden interest, what is the true need. And they learn the skills and they get better and better as they do role plays. And we kind of mix everyone up and that's how they learn. So as to the question about cultural competence, this can be difficult. And so we often have to check in with parties about what is important to them, and sometimes learn a little bit about culture in advance. Sometimes we need the services of interpreters or translators. And we try to check constantly in with the participants to learn about the culture at the same time we are in the process of mediating and trying to help them. That's an excellent question.
Great, thanks, Jody. Our next question is whether mediation services are available to businesses outside of the city of Sacramento. For example, a business in Rancho Cordova or Folsom.
Okay, that's a great question. All right, so just by way of background, we are California Lawyers for the Arts, and in Sacramento, one of our programs is called the Sacramento Mediation Center, and we handle all sorts of disputes in Sacramento County. So first, if anyone is concerned about whether they could be in the program or out of the program, they should call us so we can discuss it. The answer to your question is yes. People and businesses in Rancho Cordova, Elk Grove, or Folsom can be helped in mediation, but if they don't fall in if the property is not in the city of Sacramento, then the program may not be free to them. However, our fees are on a sliding scale. They are very low, and we try to work with every single person that calls. So we do not want fees to be a barrier.
Yeah, and so I'll just reiterate that the Sacramento Mediation Center serves broader into the County of Sacramento, just to clarify that the city's funding is only focused on the City of Sacramento. So the free services that we're discussing are really related to the city. But as Jody said, please call if you have questions about your location and whether or not you qualify for free services or the sliding scale services. Will the slides be shared? Yes, we're happy to post these on the tenant protection website with the recording of the webinars, if that's helpful to folks so that you have the information. The next question is, are mediation services available to two tenants with a common landlord? In my experience, what starts out as a dispute between neighbors escalates to the point where one or both tenants get evicted because the landlord gets frustrated with the drama between the tenants. So I think the question is, could there be a mediation where there's two tenants and a landlord involved? Jody?
Yeah, so what we try to determine, again, I would really highly recommend calling, and I know someone asked for the number, so I will repeat it, 916-850-9010. So we do get questions like this a lot, and a lot of the most important part about the mediation really happens in advance, when we can have a conversation with each side to find out exactly where the problem is. We do a lot of preparation before we ever get into a mediation. So it might be that the problem is really between the two tenants. It might be that there's a problem with the property manager or the landlord or all people. So that's, all things are possible, but that's part of what we try to determine in our conversations, is really where the issues lie, which issues to tackle first, who are the important parties.
Great, thanks, Jody. The next question is, is mediation binding? Do both parties have to agree to the solution or the written agreement that comes out of mediation? And if mediation is not successful or there's not agreement, then can someone still pursue a litigation?
Okay, so mediation can be binding if you're working very hard at making an agreement, and you make an agreement that you feel comfortable with and the other side feel comfortable with, and they reduce it to writing. You would want it to be binding because you've worked so hard to get there. It would have no value if it wasn't binding. But the first point is, you never have to get to an agreement that you don't feel comfortable with. So that's the first piece. You don't have to agree to the particular writing of the agreement, but the mediators will be using the words that you use in agreements. So you never have to get into an agreement. If you get to an agreement, it's going to be because it's your words and your ideas that are a piece of that solution. And most people would like it binding, because otherwise what value would it have? The mediation could be as little as just a discussion with the parties and no agreement. Sometimes there's no agreement, but we find out later that the parties are on a good road to trust and communication, and they've made their own agreement or their own arrangement outside of the mediation. That's still a win.
Great. And then could they still pursue litigation if they didn't feel like mediation addressed their concerns?
Yes. So first of all, if they make a binding agreement and someone fails at that agreement, they can always seek an attorney's help and perhaps sue on that binding agreement, also called a contract. So they have a way to sue on that. But if there's no agreement, no written solution, no agreement whatsoever, each person retains all of their legal rights, and nothing that was discussed in the mediation can be used against anyone in a court case. So there's no downside to going to a mediation. It's really only an upside. We encourage people to be honest and open and explore the issues that are really important to them, and to kind of think in future terms to see, we call it testing the agreement, to make sure that the agreement is likely to suit the parties in a month or two. And so, but you retain all your legal rights.
Great, thank you. The next question we got is related to unlawful detainers. So the question that I think is being asked is whether an unlawful detainer could be filed on October 1st of 2020, or does the landlord have to wait until January 28th, 2021 for residential tenants? I think you're asking this question in relation to the eviction moratorium. And I guess I would encourage you to send this in an email to the Tenant Protection Program, unless Tina, did you want
Well,
to?
I can answer it, but I would
Okay.
agree, probably with more information. For detailed questions that you have related to the moratorium itself, it's always best to send us an email. Our staff, like everyone else in the world, is working remotely. So we're typically answering voicemails. But if you send an email to us at tpp@cityofsacramento.org, that's the best way to reach us. If your tenant has properly provided documentation related to the delay of rent indicating that they're not paying their rent because of COVID, and they provide the notification as well as the documentation, you cannot issue an unlawful detainer until after the payment period, which is January of 2021. If they don't pay by that time, then you can do an unlawful detainer. But it's very clear in the code that they have 120 days from the expiration of the moratorium to repay that rent. What we're really encouraging folks to do, though, is to not wait until September 28th to kind of start discussing now with their tenant, especially if they've been paying a percentage of the rent for the last few months, because we think the more that you kind of start now planning ahead, then that tenant maybe can have a plan in place so that they're working toward it toward January instead of waiting until they only have a few months to come up with the money. But again, it's really always best if you have really specific questions, go ahead and send us an email. Our staff is really responsive, and we also work with our attorneys in the city attorney's office to provide really good, clear information in terms of being compliant with the code.
Great, thanks, Tina. The next question we have is, can a participant choose their mediator? For example, can they choose a mediator who has attorney experience or other type of experience that they're interested in?
The answer is no, but we carefully choose which attorney mediator we use and which non-attorney mediator we use. And in some cases, it might be 2 non-attorney mediators. So we do spend some time trying to figure out what would be best, what mediator might be best in any given situation. And so I hope that answered it. We don't allow the participants to choose the mediator.
Thank you. I think we have shared the number a few times, but I'm going to just share it one more time. For the mediation services, the phone number is 916-850-9010, and I will put it in the chat as requested here. We will make the slides available. We confirmed that. Okay, the next question is, I'm a landlord and I need to sell my property. My tenant has been living at my property 3 years and is currently out of the lease and on month to month. Can I give my tenants a 60-day notice? If they refuse to move out, what can I do? Would mediation help in this case? Who wants to start on this one?
I think when you have that kind of specific detail, that's one that's really best to send us an email about, because there's so many different questions, there's different issues. From case to case, it varies. So I think for us, we really want to make sure that we have a full understanding versus giving an answer here and giving misinformation. So the more you can send us an email, really explain what's going on with your situation, then we can really look, because in some cases, some things are going to be related to the tenant moratorium ordinance, but the city has a whole tenant protection ordinance where some things, especially when it comes to evictions and different issues, where that may come into play. And so we can determine whether or not it's something that's subject to the moratorium or whether or not it's subject to the city's overall tenant protection ordinance. And that way we can better assist you in really giving you an appropriate answer to your question.
Yeah, I think that that's the perfect place to start. And then if there was need for mediation services, that could potentially be an option. But I think Tina's right that we would need more detail on what the situation is and what local ordinances do apply. Great. The next question is, someone's asking whether they qualify for the free mediation services. They're a commercial tenant and there's a zip code that they're providing. I would just ask you to call the phone number. We're going to look and see if it's within city limits. The city limits are the area that we're serving with this program. But you're encouraged to call the phone number at 916-850-9010. Can tenants in public housing access these mediation services? Yes, we're not limiting this to people outside of public housing. We are needing to tie it back to COVID impacts. We are using federal CARES money or COVID relief funds to assist in providing these services for free. So we will be looking at its link to COVID, but we aren't excluding any residents in the city at this point. What about tenants who file the paperwork late? I have talked to many tenants who did not find out about the paperwork in time and turned it in after rent was due, but clearly had a COVID-related loss of income. Tina, do you want to start this one?
Yes, one of the things that's really great about the mediation services is that unfortunately, if they didn't comply with the code, they wouldn't be covered by the code itself in terms of failing to meet the requirements of turning in the documentation. However, mediation services are available regardless of participation in the delay of rent program. So if people weren't able to take advantage of the delay of rent program, we still strongly encourage them to use the mediation services and to work with with those folks there to see if they can mediate and provide, the information that it was related to COVID and see if they can come up and work a plan. And again, they also may just want to contact our office and we may be able to provide some additional assistance once we get a better understanding of what their situation is. But again, the really great thing about the mediation services is that it's available because our goal is to try to keep people in housing. And so this service is really trying to give people a way to communicate. So we really encourage folks not to think that they're out of luck because they didn't comply with the program, because through mediation services, they may still be able to reach a common ground with that landlord because they can show intent and they can show the reason why they're late, and they may be able to come up with some kind of negotiation and mediated contract that they can work through.
Great, thanks so much, Tina. The next question relates to the mediation case prep and how mediators are selected for a given case. Jody.
All right, so everything starts with an initial call. We spend a lot of time with the first caller that we often call P1 or party one, participant one. So we spend a lot of time understanding their side of their story, what they are concerned about and what they would like to see happen. That call is confidential. If they want to open up a case, we reach out to the other side. In speaking with the other side, we get the other side of the story, what they are going through, what they are up against, what they would like to see happen, and that call is confidential. And we work with both parties separately to kind of hone the issues and figure out where they might be headed and what they would like to see happen. And sometimes a little bit about what kind of emotional state they might be in, what kind of, are they business savvy or not, or are they in a very tenuous emotional position or things like that. So we get a feel for what they're up against, what they're dealing with, what their personality might be like. And from that, when the parties are ready to mediate, then we go to our list of mediators, our panel, we call it, and we look to see who might be good working in this situation. And sometimes, we'll get one person we really want to work with, but we don't have a good time frame for the other person to work with. So it is a balancing act between all four people, two co-mediators and the participants, and maybe even additional people like lawyers or support people. So it's hard to mesh schedules, so that's part of what we work on. And that's basically how we choose the mediators. So I will say sometimes participants don't want to be face-to-face with the other side. Some people aren't ready to speak to the other side. Some people aren't confident of their skills. And so in rare cases, the mediators, our staff, will go between the parties in a process called conciliation and try to help the parties come to an agreement without actually being face-to-face. Being face-to-face in an actual mediation is the best way to go, it's best to be able to see nonverbal communication and to really get a feel for what the other side is presenting and really dispel some of the anxieties and fears that people have when they start the whole process, because I think everyone feels so much better once they've been in a mediation, even if they haven't come to their exact solution. So the mediators are very important. The most important part of them is that they're trained and that they're ready to handle the participants that are in front of them.
Great, thanks, Jody. We have a question from a landlord who is interested in their options and eviction options related to a tenant who wasn't paying prior to the moratorium. Is this another one that you would recommend an email for, Tina, or any comments?
Yeah, I would definitely recommend an email. I think non-payment of rent. And again, if someone wasn't paying rent before the shelter in place and before the ordinance was adopted, if they just weren't paying rent, they aren't protected by the code. But there may be other factors in play. So again, I would suggest emailing our office. In terms of eviction, the courts are currently closed. And so even now, even if there is cause, until the courts open up, there isn't an ability to evict a tenant. But again, send us a little bit more information and we can tell you what the different options are. So that way you can understand kind of what's going on. And again, with our attorney's office, we can kind of get a better understanding of how it fits in with either one of the programs.
And the email address is the tpp@cityofsacramento.org. We got that as a follow-up question. So that's the email address if you have questions about, if you're that individual asking about the eviction process or any of the protections.
And again, just a reminder in terms of folks asking for us to repeat numbers and everything else, Danielle did a great job in terms of putting the PowerPoint together. That contact slide has all of our resource information. So it has our emails, our phone numbers, our website information, and all of those are really great resources. And I know from our website with the Tenant Protection Program, we also, in our emails, we also provide information and resources to other folks that can assist people with rental questions.
Great. So we have a question on here, whether the information applies to both residential and commercial tenants today. I just want to affirm, yes, we have protections for both residential and commercial tenants right now with the eviction moratorium. And if you need those details, either circle back on the webinar or look at the FAQs on the Tenant Protection Program website. And the mediation services are available to both residential and commercial tenants and landlords. So just to be clear on that. We only have a couple more questions. I'm going to try to get through them here before we wrap up. I owned a property since 2018. I inherited tenants from a previous seller, so I have not renewed their lease. So it's basically month to month. Oh, this is more information on, I think, one of the questions from before. So if you could go ahead and send us an email, we'd be happy to discuss specifics offline on any of these questions related to evictions or non-payment or any of those details. I think that's actually the rest of our questions. There's one in our Q&A that I'm jumping over to. Are mediation services available between landlords and lenders as well? Huh. That's a great question. I think if you would contact us, we'd be happy to talk through the specifics of the question. The focus has been on landlords and tenants, but if you want to talk through it, I think we'd be happy to do that. And then it looks like we have another specific question about an owner and a tenant who has lease specific questions. So if you either want to send an email over to Tenant Protection Program and we can start there and see if it relates more to the city ordinances or the mediation services, that would be a great place to start. I think that is all of our questions questions coming through on the chat and the Q&A. So I just want to take a minute and say thanks to both Jody and Tina for the time and the information. And I just want to reiterate that the city is really excited to have mediation services available and to provide them to the community at no cost. So please, if you have questions about anything in this webinar, if you could go back to the resources page and feel free to either call or email the Tenant Protection Program or our mediation services. We look forward to providing this service to the community and look forward to working on all these cases together. So thanks for everybody's efforts in ensuring that we can keep our businesses and our residents occupying and our landlords taken care of and finding mutual agreeable solutions for everybody. So with that, we will go ahead and close the webinar, and thank you for your participation. Our next webinar will be Wednesday at 2 o'clock.
Thank you.
Thank you, Danielle.